All right, so good afternoon, everybody. It is February the 28th, the last day of February in 2025, and this year is moving so quickly. So I am excited to get back on track here. I just want you to know I spend quite a bit of time putting these trainings together. I call it the Great Connie Brain Dump, but in reality, I have to take all that information that's in my brain and put it in some type of organized fashion. So when you see things like you see today, the understanding the jargon and the acronyms and stuff of CPS, these are things that I just know in my brain. And when I go into courts and they talk about CFTMs and DNs and TPRs and COEs and whatever, I mean that's part of that language, and it's so important because they try to trap you in your lack of knowledge. And so that's one of the main purposes of going through this training process is so you don't get trapped in a lack of knowledge. I mean, I know as an attorney, it's kind of an us and them situation when you're involved with the court system. They think they're smarter and they think they know all the little secrets. And so if the more you just understand about that process, and if you don't, if you watched our last training on the step by step, I talked about asking questions and you've got to ask questions. And trust me, even when I started working cases within the juvenile system, there were times when I didn't know all of this. They'd say CFTM, and I go, what is that? I would just ask the question. So, but I want the people who are, wanting to be advocates and for their own case, as well as wanting to be advocates that they can understand the language a little bit before they get involved. All right, so we are going to go on share screen. Patient with my mouse here. All right, and I will say if somebody, once in a while I have just to double check and see if there is a participant that didn't get in. Yep, there's one right there. So give me just a second. Get somebody fell off and get them back in here. Good. Okay. All right, so this, I just call it words, terms, and acronyms in CPS litigation and case management. Again, not a very interesting sounding topic. I'm going to put us over here in the corner, I think, if I can, so I can see you all. It doesn't sound like a very interesting topic, and it's not very interesting, but it's very critical. All right, so learning to speak the language is CPS. So there are a certain set of words that are used in investigation and case planning, such as substantiation and case closure. There are words used in litigation, such as adjudication and disposition. There are legal words such as subpoena, res judicata, burden of proof. And then there's a glossary where you just need to understand what are the definitions of abuse and neglect and psychological neglect, etc., when the agency is considering proceeding against a parent. And there are tons of acronyms. There are many acronyms. We're going to pick out a few of the most important. I think I found, one gave up to 8 pages of acronyms, and I have about 4 pages in it, so they're all covered when we get to them. So, like I said, don't fall asleep. It's not going to sound very interesting, but very critical. Also, for those of you who are new, I do record this on Zoom. I do once we are finished with the training today. I will download it, and it downloads both a video and an audio separately so that I can upload the video to YouTube. I can upload the audio to Spotify, and then I post both of those links right in the Family Forward Project, as well as I do have a YouTube channel called Family Forward that I opened just to be able to put the trainings on. I have posted just a couple short videos on there that are just kind of descriptive. But that Family Forward YouTube channel is primarily just for our training. So because my YouTube channel has tons of stuff on it and the trainings would totally get lost. I also am setting up through WordPress because I've had a WordPress website for a long time, and I have set up a page on there for advocacy training where I am linking in all the trainings, I've embedded the YouTube, put a link to the audio, and most of these I'm getting up on uh, Google Classroom. The Google Classroom is a little bit complicated for you to maneuver and to get into, and I appreciate that. But unfortunately, all of the other sort of classrooms that we would take a look at involve downloading an app generally, and I'm trying to avoid people who want to train from downloading an app. Maybe some later time we might do that, but I'm trying to avoid that. So I'm trying to put the Google Classroom in the WordPress doc as well. All right, now here's my first attempt to humor you through this very boring. And here's your first riddle. So, why shouldn't pigs drive? Now, don't look it up. Don't look it up. If you have any guesses that you want to put in the chat, we'll open them up after the training's over and see what kind of guess that you had. All right, so why do you need to know the language? So you need to understand the chatter of social workers, lawyers, judges, and others because they just spurt this stuff out, okay? They just, chitter chatter, CFTM, DNN, when's the TPR? Are we doing a disposition? When's the adjudication? I mean, if you walk into a courtroom for the first time, you will think they're speaking another language. And I know I started somewhere just like you all did. Also, so the CPS players can't make you feel stupid. Like I said before, they try to one up you on knowledge. They want to be, it's them versus us, right? So they want to one up you and chatter around you, thinking that they're going to lose you in the dust. So it's so that you don't feel stupid. And so the parent and advocate can think ahead to the next step and keep the players on their toes. So if you've been watching my trainings, I do have one of my trainings called The Politics and Players of CPS. And I kind of go through like, who are all these people that are involved? Because a parent walks into the courtroom for the first time or goes to a CFTM meeting, they see a dozen people in there and they have no idea who they are. So we want to be able, as parents and advocates, to make sure that we assume or that we assimilate whatever they're talking about immediately and can keep them on their toes and stay ahead of them. And so that the parent and the advocate can hold CPS and the players in check. And of course, we want to win. All right, so I'm not going to give you the answer to the riddle here for a while, so you just have to sit tight, but that is coming. All right, so first we're going to look at legal terms. All right, now I've divided these legal terms. I've tried to categorize some things. So, and we're going to have some further slides that get into these into a little bit more detail. But legal terms like subpoena, petition, court order, hearing, adjudicatory hearing, dispositional hearing, review hearing, permanency hearing, TPR hearings. Now, there are more, they have labeled more hearings in CPS cases than they do in any kind of other civil litigation. In civil litigation, you either have a trial or a motion hearing, and that's just about it. But here, everything has a different label, and that's why it's so important that we need to know what they are. And we're going to go through these in later pages. All right, so legal terms. So let's talk about some legal terms. So a subpoena, petition, and court order. These are some of the just very basic things. So over here on the right-hand side, you will see where I have sort of put my description. So the litigation process starts with a petition. Along with a petition, the state may request a removal order from a judge without a hearing, which is called ex parte. If the judge enters an ex parte order, the agency can immediately take your child and must set a hearing within 72 hours, not counting weekends, by the way. So taking your child on Wednesday may mean that you won't even have a hearing until Monday. And then after that occurs, there is a preliminary hearing, and the judge must decide if there is probable cause of the allegations and the least drastic remedy for the safety of the child. And the judges will enter a preliminary or temporary order. And the subpoenas must be used to compel witnesses who come to court, and parents must know who and what to subpoena. Now, we have also talked about this in the past, particularly as it relates to records like school records, medical records, etc., supervised visitation records. All of those need to be under subpoena. All right, and back over here on the left side, the subpoena, just the definition is it is a legal document that commands a person to appear in court or produce documents relevant to the case. And in child welfare cases, they are often used to compel witnesses or to obtain records. The petition is the formal request to the court for an order or ruling. In child welfare cases, the petition might be filed to request the removal of the child from the home or to terminate parental rights. Now, I do want to say that these petitions must have to be verified, and verified means that they have to be under oath. And why is that important? Because unfortunately, social workers lie and caseworkers lie, and they're the ones who verify these petitions. And I'll give you a very good example. Well, generally, they only put in the referral information, so they don't have any personal knowledge. But I do have where social workers go too far, and they say, for instance, the parent refused to cooperate with CPS or DCS, and the parent has actually given an attempt to try to work with them, and they put that under oath. It's a false statement, and so we want to make sure we point that out to the court. And then a court order is the document created and signed by the judge or magistrate, which directs the conduct and the rights of others. And unfortunately, I think judges have way too much power, but that's what court orders do. All right, so in legal terms, a hearing. So a hearing on the left side is a formal proceeding before a judge or magistrate where evidence is presented, legal arguments are made. The common types of hearings are adjudicatory hearings and dispositional hearings. On the right side, a hearing is an appearance in court where each side of the litigation should have the chance to present evidence and argue their position. And I just put that on here in black and white because so many times, time after time after time, I have parents tell me that they go to court and they don't get to be heard. Their attorney won't say anything. They don't get to say anything. So due process requires two things: notice and the opportunity to be heard. Notice is notice of the issues that are before the court, and the opportunity to be heard means that each person should have the ability to state their position. Many parents say they are never heard in the courtroom. Make sure parents receive a copy of the court papers and review them with them if there are obstacles to understanding. And there are certain confidentiality requirements that we must always be aware of. The juvenile court documents are confidential and cannot be disclosed to the public. But if the parent needs assistance in reviewing them and understanding them, because this is quite a traumatizing period, then that does not breach confidentiality. And help parents to outline the message and evidence they want told in court and write it down. Help identify if subpoenas are helpful. So this is going to be part of the role of the advocate. When there is a motion, when there is a petition, to kind of sit down and outline, okay, this is what the petition says. Because I'm going to tell you, some of these petitions are horrible sounding. I mean, they are terrible, terrible, terrible. And they omit things and they twist words around and they sound really bad. So it's so critical that we ask the parent the question about everything that's alleged in there, because the attorneys often don't even do it. They will look at these petitions and they'll say, like, I don't know, this is pretty bad. Like their house is dirty, and they'll make a bunch of statements about that. They were living in the basement. They had puppies in the bathtub. I mean, you just always have to remember it's a snapshot. However, you want to make sure you go through that you go through that together. All right, legal terms, adjudication and disposition. These are words that you never hear hardly outside of the courtroom. An adjudicatory hearing is a hearing to determine whether the allegations of abuse or neglect are true, and it's similar to a trial, but a little less formal. Now, I'm going to say it's not really less formal. It seems less formal. They will not always follow what, if you are a litigation attorney who does, for instance, car wrecks or criminal cases, you find a pretty set procedure that you don't see in juvenile court and adjudicatory hearings. So I don't know if I would call it less formal or if I would call it maybe perhaps what feels like a bit more chaotic. A dispositional hearing is the court hearing to determine the appropriate course of action after finding abuse or neglect and its decisions about placement and services, etc. So over here on the right side, I say adjudication is considered, sorry, I got a typo there, the ruling, and sometimes called the final order of the case. An appeal can be filed only after all issues are adjudicated. It requires clear and convincing standard of proof. The disposition is the final ruling on a petition for dependency and neglect. So first you have an adjudication, like, is it true? Is there abuse? Is there neglect? And then only after there being an adjudication can the court move into a disposition, which is really now what's going to happen, right? Now what do we do? So the petition has several options, and disposition and foster care is not the only option. The standard of proof changes. So standard of proof means how much proof do you have to have. So the clear and convincing standard is supposed to be pretty high. So you have preponderance of evidence, clear and convincing, and then beyond a reasonable doubt. And of course, criminal courts are beyond a reasonable doubt, but it doesn't require quite that level of proof. But honestly, these are judge cases anyway, and I don't know that they follow that. I don't know that they understand the difference. And I've even had judges tell me that before, that they never understood the difference with clear and convincing evidence. The disposition is the final ruling of the petition. I already said that. Okay, let me move on here. They can, under disposition, relatives can seek custody, and a plan for return to parent can be considered, and reliable hearsay is allowed. Now, a lot of parents get real anxious about this because the agency can use reliable hearsay. And how do they use it? They do it like the caseworker comes in and says, well, the foster parents say that the child is always upset after a visit, right? But the parents can also use it, and the parents can say, I talked to the foster parent about this, or, the child told me this. So there is some avenue for that to work on both sides if you appropriately use it. And an appeal is permitted after disposition, even if the court continues to have hearings on permanency and placement. And so, it almost seems like these cases never end. And honestly, until a TPR, they really don't end. They seem to go on forever. All right, so here are some of the other hearings. There's review hearings, permanency hearings. There can also be a permanency plan ratification, and there can always be motions such as visitation, medical participation, relative placement, and discovery. The review hearing is to review the progress of the case and the implementation of the court's orders. It can include assessing safety and well-being and parents' compliance. The permanency hearing is to decide the long-term placement of the child, or even if long-term placement is appropriate. And these hearings occur in the course of litigation. The court is supposed to have a hearing every 6 months on permanency. So the state agencies often create litigation fatigue with parents by filing motions to bring them back to court. Hang on one second here, let somebody in. Filing motions to bring them back to court over and over and over without resolution, then continuing the final hearing date so the parents can never get to the appeal process. The parents need to use motions to their advantage and be prepared. Permanency plan ratification hearings are among the most important, and almost everybody ignores them. All attorneys ignore them. A parent can object to the permanency plan, especially if the agency insists that the parent is not cooperating, and yet the parent says they are cooperating, and to show the judge the documents and the progress in the case. Parents must also get discovery in this process. Motions are important for discovery. Now, I think we've talked about discovery before. I'm just going to talk about it briefly, which means you want to know what the other side has that they're going to use against you. So discovery means all of the CPS records, all of the FAST assessments, all the assessments, CANS assessments, FAST assessments, all of the assessments on other alternative relative placement, all of their attempts if a relative's out of state to get ICPC, and you also want to ask for all their email and text message communication. You want to make sure you get all supervision notes, etc. So you need to know everything in their file, and they have to turn it over. Now, they don't like it, and they may make the parents sign a protective order, but that discovery part is extremely important. All right, termination of parental rights hearing. A court hearing to determine whether the parent's rights should be permanently terminated, allowing the child to be adopted by another family, or I call it the stranger adoption. Termination of parental rights is the death sentence for parents, and careful preparation is critical. It's so critical. And, just as a matter of logistics, so often we see that by the time that CPS has brought a petition for parental rights and gets that before the trial, that litigation fatigue has just worn out the parents and worn out their attorneys, and they may have to get another court of appointed attorney for the parental rights after the DNN. And now they have the disadvantage not only of just this litigation fatigue, but often a brand new attorney will be appointed. And now that new attorney is starting from scratch again. So there are several parts of this process that that advocates have to stay on top of, and that discovery process is a big part of it. So this TPR is a totally separate proceedings from the dependency action, and the state has several statutory, which means legal options. That just means things that were created by the legislature for termination of parental rights. These laws have undermined the prior parental fitness standard. Under the Constitution of the United States, parents have a 14th Amendment right to parent their children. And there are, in the Supreme Court opinions, it talks about fitness to parent. And unless you can show that a parent is unfit by clear and convincing evidence, you cannot terminate their parental rights forever. Well, what's happened in every single state of this country is the General Assembly, the legislative branch, has gotten a hold of it, and they have statutorily created conditions which can cause a termination of parental rights, and in their determination, it makes a parent unfit. A couple of them that are very frustrating. One of them is the failure to pay child support once a child is put in foster care, which I totally disagree with. Completing the permanency plan, which unless parents have had hearings on permanency plans as to whether or not they were even critical in the first place, this is an unfair and not really a substantive issue of unfitness. The state in the TPR must also show best interest. These factors are numerous, and parents should start building their best interest facts constantly during the course of the entire case. So what are best interests? So again, the General Assembly, the legislative branch got a hold of the best interest, and they start articulating it as a list of factors. And we'll probably go through this in one entire training. And it can be things that like, I don't want to quote them because they use sort of a legislative language, but generally speaking, they will try to show that the parent's emotionally unfit, the parent doesn't pay child support, the parent doesn't have a suitable home, the parents refuse to cooperate, parents refuse to visit, parents failure to visit or pay support. So these are all best interest factors. So parents need to start building these. They give parents this little notification, this little notice that if you don't pay child support, that your rights could be terminated, but they don't really kind of educate parents on all of the different factors that could put them in that situation. All right, roles and representation. So again, this is kind of an overview of all of them we're going to talk about, and then we're going to go through these separately. So the roles are the guardian ad litem, the attorney ad litem, and court-appointed special advocate. And this is, of course, in addition to attorneys and judges and court officers, et cetera, and state's attorneys. Those legal concepts of best interest of the child, and due process. So the guardian ad litem, we're going to go over this in another slide, so I'm just going to skip over this one. Okay, guardian ad litem, attorney ad litem, and court-appointed special advocate. So on the left side, they are a court-appointed individual who represents the best interest of the child. The GAL investigates the child's situation and makes recommendations to the court. On the right side, the GAL provides a pivotal role and can heavily influence the judge. I want to be perfectly clear on this. Most of the time, the GAL takes the side of the state agency and only serves as a second chair to the state. This should be addressed. And I have brought this up in court before, where the guardian ad litem sits over at the state's table. And I'm like, why are they sitting with the state? Like, they need to be prosecuting their own case and making a determination about what's best for the children, not what the state wants to happen. So that should be directly challenged. The attorney ad litem is a very particular role that's a little bit different. So on the left, they're appointed by the court to represent the child in legal proceedings. The AAL ensures that the child's legal rights are protected. Now, what does that mean? So under the 14th Amendment, the substantive due process right of families under the 14th Amendment is family integrity. That is a right that is protected both for the parent and the child. Excuse me. So the attorney ad litem, over looking at my notes, each case should include an AAL unless there is severe abuse. Most children want to go home, and the AAL is required to advocate for the child's wishes. It also requires that the GAL cannot meet with the child without the AAL present. To do their job, they should conduct discovery, increase contact with parents, protect the child from invasive medical treatments. Almost nobody gets an attorney ad litem involved. In East Tennessee, they call them preference attorneys. I don't know why they've selected that. It's not statutorily defined very well. In Tennessee, the only place you will find this even mentioned is under the guardian ad litem rule, which is a Supreme Court rule. It does have one tiny little section that says that if the guardian ad litem's desires and the child's desires are in conflict, in other words, what they want the outcome to be, that the guardian ad litem will inform the court. So it doesn't, and they don't, right? They just don't because it limits their ability to talk to the children, etc. So I have actually filed these motions on my own, asking for an attorney ad litem for the children to litigate for the children's desires. And then CASA is the nonprofit that provides non-lawyers, advocates who fill the best interest role. They are rarely equipped for this role. They're very myopic. They create reports that must be shared with the parent. They love to create reports and file them with the court and never give them to the parents. And I've seen it myself. Again, these are all things that I've had to fight. And so as an advocate, a parent, or an attorney, you need to be making sure, and so I've even asked for a court order before that CASA or the guardian ad litem cannot file reports with the court unless they are provided to the parent or family, and they should be provided at least 5 days in advance. You don't want to walk in the courtroom, and this is what they love to do, and you walk in the court for the beginning of a hearing, and they pass around reports that they filed with the court, and it just targets the parent and says all kinds of horrible things against the parent. So we want to prevent, and the state agency can do this as well. So we want to make sure that we prevent this. All right, these legal concepts, best interest of the child, clear and convincing evidence, preponderance of evidence, and due process. So on the left, the best interest of the child is the legal standard used by the courts to make decisions about custody, placement, and other matters about the child's welfare. and the court considers various factors to determine what is in the best interest of the child. Then on the right side, the best interest of the child has diluted all inquiry into the child's constitutional right to family integrity, what I was just talking about before. And every single person should be bringing this up and saying, you know what? This child has a right to have a relationship with their family as well. And somebody needs to be protecting that right. Parents are caught off guard and attorneys are rarely prepared. This is where family members, school records, medical records become important. All right, clear and convincing evidence. So it is a higher standard of proof on the left than a preponderance of evidence, but lower than beyond a reasonable doubt. This standard is often required in child welfare cases, especially in a termination of parental rights. All right, then on the right, I say it has become diluted since all dependency cases are heard by a judge only. Okay, so how do you think a judge makes that differentiation or that distinction between preponderance of evidence and clear and convincing evidence? There's no scale, right? It's all 100% subjective. And so when a closing argument is made, by a parent's attorney or by a parent if they're trying to represent themselves, one of the things that they need to make sure they argue is the clear and convincing evidence standard, because it is a very high standard. And, most of these things we're going to talk about again. And as you learn the general concepts, we will get into more and more, the real legal language, the way the legal language is structured. But I have decided it's best just for you, first of all, just to understand conceptually what these words mean, and then as you start to assimilate this knowledge, add the higher level of detail with the actual, like a case law site or the term from Black's Dictionary, right? Now you'll be able to look those up, and you could. So, you could go look up like United States Supreme Court clear and convincing evidence, and you can find certain descriptions, within the law and within the cases. But for now, I just kind of want you to conceptually understand it's more than a preponderance of evidence. So preponderance of evidence on the left side is a standard of proof used in many civil cases, including some child welfare cases. That means that evidence present more likely than not to be true. So that's what we call the 51% test, right? Like you don't have to be like this. The proof just barely, I don't know if you can see my hands or not, I can see them, but the proof just has to be a little off balance and tip to one scale or the other. That is the 51% test. And on the right-hand side, the preponderance of evidence is a very low evidence standard. It's very low. I mean, it's like almost if you have any evidence. Now, think about things like, let me see if I can give you a good example, like a car accident, maybe. And so in a car accident, you have two sides to the story. You have a plaintiff and a defendant. So the plaintiff describes like how fast they were driving on the street, and, they put on their turn signal and they went to make a, left-hand turn, and this car hit them, right? And then the other guy gets up and says he didn't have on his turn signal. He was speeding, and, I did hit him, but it was an accident that was caused by his driving. Okay. So you have two stories. Now, remember, most of the time in these cases, there are not two stories. It is the parent's story and the state basically creating a narrative that around a story, and the state gets to go first. So the state can put the parent on, can put the caseworker on. They can be very hostile to the parent and trick the parent into saying certain things. So it's really the state has the opportunity to go first, put on some facts, twist the narrative, and then the parent's attorney and the parent are trying to dig themselves out of this hole. And so it's always their burden of proof, but the truth of the matter is that they create such a narrative around the facts that they have, and it makes it very difficult. The due process, I talked about a little bit, but on the left side, that is the legal requirement that the state must respect the legal rights owed to a person. Ha ha ha. In child welfare cases, it ensures parents and children have the right to a fair hearing and other protections. And my notes say due process is procedural and substantive. Okay, so procedural due process is notice of what is before the court and opportunity to be heard. And substantive due process is the protection of constitutional rights, such as family integrity. All right, so I want to talk just a minute about procedural due process because this is something, it doesn't sound like much, but this is also something that advocates, parents, and parents' attorneys need to be right on their toes to be able to protect the due process rights of the parent. What will happen is they may walk in court, think they're having a hearing on one thing, and then CPS attorney will flip the script. And I don't know, you may think you're going in for a motion on, maybe the state wants you to have supervised visitation, or even worse, let's say the parent files a motion to increase contact and visitation, and you get to court, and all of a sudden now the state says, well, Judge, what we really need to talk about today is XYZ. What we really need to talk about today is vaccines for the children. What we really need to talk about today is, cutting the parent off, their, supervising their time. So as soon as you should never, ever, ever allow a parent to be hijacked. You should not be hijacked. It is not trial by ambush. They are not permitted to ambush. They have to give notice ahead. That's why we do things in writing. Now, they will come along and they'll say, well, juvenile court is more relaxed. It's not so structured as a regular courtroom, but that does not dismiss due process. And due process has two features. Procedural due process is notice and opportunity to be heard. All right, court orders and decisions and legal actions. This is an overview, and then we're going to take a little dive into each one. The court orders and decisions, we have temporary, permanent, reunification, protective orders, legal actions such as a motion to dismiss, contempt, and the appeal process. And let's take a look at those. All right, so court orders and decisions. Here on the left, the temporary custody order, the court orders that temporarily places a child in the custody of a non-parent, such as a relative or foster parent, while the case is being resolved. And my note on the right says that they are modifiable at any time. A court can be asked at any time to modify a prior temporary order. You've got to remember this. Now, judges do not like to do it, but by law, interlocutory orders or temporary orders or orders that are put down in the middle of a case are temporary and modifiable. They try to build some rules around this that say, well, it can only be changed, blah, 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 with permission of the court, blah, blah, blah. But it doesn't matter. Those issues need to be brought up. And they need to, because they drag this litigation out, the parent should always be continuing to process more time, more visitation time, more contact, putting before the court that they've completed the things that they're supposed to do. All right, permanent custody orders. On the right, the court order that establishes the long-term placement of a child, which may include reunification, adoption, or guardianship. All right, so my notes on the right, a permanent custody order. Most judges are going to say custody is never permanent, meaning that parents have the right to ask to amend orders where there has been a change. So it's not permanent until it's over and there's a termination of parental rights. This is the order, though, from which an appeal can be taken. A reunification order on the left, a court order that outlines the steps and timeline for reuniting a child with their parents after separation. And a reunification order over here, you see my notes, it says an animal facing extinction, because I have not seen a reunification order. Well, I did do a reunification order in 2020, I think, or 2021 May. No, I think it was 2020. It was at the end of the year. So we were at that sort of pandemic cusp, and we'd had a lot of problems getting this case through the pandemic. But I did get a reunification order, and I will tell you, I made it very, very, very specific. Now, I moaned and groaned about it because I said, you took this baby away from her dad, in one fell swoop, and you should take her home in one fell swoop. But it was a young baby. Mom had had some problems with addiction, so she was going to her dad. And, I knew it probably was okay for dad to have some time to adjust, make sure his house was okay. So instead of just dropping the baby off, but we made it very specific. Like she would immediately have an overnight, and then he would, take her back to the foster home. Then she would have, 2 overnights, then 3 overnights, and made it very specific, put dates in it. So there'd be no question about what everybody needed to do, because they tried to put a lot of hiccups in there and a lot of what ifs, and like, unless the baby is upset, or unless the baby this. And I'm like, no, 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 if you have a problem, you need to take it to court. All right, so the last one here is a protective order. And on the left, it is a court order that prohibits a person from engaging in certain behaviors, such as contacting the child, entering the child's home, or to protect the child from harm. All right, so my notes on the right tell you it could be in the form of a restraining order to control conduct, or a protective order can also be the name of the order that is put down to protect the disclosure of documents. This could go to CPS documents, such as forensic interviews and CPS records, but can also be applied to the parents, and should be applied to the parents should CPS try to get things like their medical records, mental health, substance abuse records, etc. Parents should likewise be seeking a protective order and a destruction order. So if you get CPS records, generally they put in there that you will destroy all records at the closure of the case. And the same thing should be true in the reverse if they're getting too intrusive with requesting records. All right, legal actions that can be taken during the course of proceedings: a motion to dismiss, a motion for contempt, and an appeal. So a motion to dismiss on the left-hand side is a request by a party to a lawsuit to dismiss the case, and it's often based on procedural grounds or lack of evidence. And I explain it on the right, and I say this can be done, number one, at the commencement of the case, or number two, after the state closes their case, presents all their evidence at the adjudicatory hearing or TPR hearing. And attorneys rarely use this tool, but should always use it in these hearings. All right, so one, let's look at that, the commencement of the case. So that has to be by motion, where there would be a motion filed to dismiss the case, just because perhaps it doesn't even state abuse or neglect. And then number two is after the state closes the case. So you get in a trial, and I have used this before many, many times. So you get in a trial for adjudication with CPS, and they put on all their proof. And before the parent's attorney or the parent starts presenting their case, they ask the court for a motion to dismiss. And you say, Your Honor, they haven't carried their burden of proof, and so I want to dismiss the case. And that's before the case even goes any further. And that should be done every time, because sometimes they do not present, they think they're going to hold off and present their evidence in cross-examination of perhaps another witness. And you don't want to give them the opportunity to do that if you don't have to. All right, so a motion for contempt on the left is a request by a party to hold another party in contempt of court for failing to comply with a court order. So it can be failing to comply, or it can be doing something that was prohibited by a court order. So it can go either way. So it can be complying with an order or violating a court order by doing prohibited conduct, such as contacting a child, if for some reason you were told not to. On the right-hand side, my notes say that the motion, which can also be filed as a petition, sometimes it's called a petition for contempt, if a protective restraining order which controls conduct is violated by anyone, the court can punish them. This is often used on parents, but can also be used on caseworkers, can be held in contempt if the parents can get a clear order to control their conduct. So let me give you an example. All right, so Discovery is a good one. I have asked for discovery before or subpoenaed a caseworker to give me discovery before, and they don't do it. And then I get an order from the judge compelling them to produce discovery, and they still don't do it. And then you can go after them for contempt. And I have been aggressive about with this. And one of the complaints they made about me that I was too aggressive in seeking motions for contempt. But if people don't comply with a court order, that's what you're supposed to do. All right, on the left-hand side, the appeal is the request of a higher court to review a decision by a lower court. In child welfare cases, appeals may be filed by parents, guardians, or the state. So my notes on the other side, an appeal is a request for another court to review the decision of the trial court. This next part is very important. In some states, a dependency case permits a de novo, which means brand new hearing in circuit court. Some appeals are reviewed by the appellate court, which are on the record only. So let me talk about that just a second. So when you appeal, remember we talked about the adjudicatory order and the dispositional order. So once the dispositional order is entered, an appeal can be filed. Now, the way the law is written in Tennessee, you can then take that, you can file an appeal directly to the circuit court and you start over. Brand new, you get to do discovery again. You can a subpoena witness, do depositions, etc. And this has been very valuable. Sometimes if you have a really biased judge, you want to try to get it through the juvenile court and get it up to circuit. And you will find, I have a case right now, I'm working with somebody and they are actually doing everything they can to exhaust this mother with litigation fatigue before they get her to a final order so that she feels like she won't be able to appeal. But they don't like the fact they may get out, they may have to get out of their playground and do a brand new hearing in another courtroom. Now, on the record, what does on the record mean? So when you appeal to a court of appeals, which is a reviewing court, it is on the papers only. It's on the transcript, on the motions, on the pleadings, on the evidence, but it's on the paper. It is on the paper. And so if a judge has made any credibility findings, which is one way that they secure their decisions by trying to say that somebody's not credible. But that if they've made credibility findings, the court will usually uphold those, but sometimes they won't. If they don't have any support to back it and they just say, and all they say is this person was not credible, it may not stand. But it means, and it's written, it's very detailed. An appeal on the record only is very, very, very complex. Okay, I don't know if y'all lost in your head what my joke was, but why don't pigs drive? And here's the answer, because they hog the road. Arr, 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 arr. All right, so let your brain shake out for a minute before we go. I may have to get a little bit more water. All right, so here we go. Whew, into the next part. All right, now there is no way to just put together a list of acronyms and in a list and put, boy, you can tell my brain was getting sour when I wrote this, can't you? No way to put a list of acronyms in a list and read through them and expect you to learn them. There's just no way to do that. So we're going to look at a few key items, but there's a ton, okay? Acronym cheat sheets or acronym pages are going to be uploaded to the Google Classroom and the WordPress training page. And you're just really, probably I'm going to have to advise that you just download those and print those because you should have sort of a cheat sheet list with you anytime you're involved in the CPS case. All right, here's your next joke. Oops, sorry. Where do polar bears keep their money? All right, don't say it out loud. Think about it and don't look it up. You can put it in the chat if you think you have an answer. But here we go. Are you ready? Next deep dive. I told you it wasn't going to be easy. All right, so here is where we're going to start our list. All right, just take a look at these for a second. You can go through them. These are some We have a few pages. I think I've got 4 pages. So just hold on tight. Don't fall asleep. Don't snore if you do fall asleep. These are acronyms that you're going to see a lot. Now, I'll also tell you that I do also download I print the trainings to PDF and I do upload them as well. Now, I usually do 4 sheets to a page, so it's a little bit smaller. But like I said, I've already uploaded the cheat sheets on acronyms, so you can print those off and take a look at them. All right, so here we go. So AA is adoption assistance, AAL, attorney ad litem, ACV, you're going to see that initial in the actual records, which is the alleged child victim. ADD, most people know that as attention deficit disorder, and ADHD as attention deficit disorder or with hyperactivity. ADA is Americans with Disability Act. AG is Attorney General. ASFA, ASFA is the Adoption and Safe Families Act. BIP is Behavioral Intervention Plan. CAB is Community Advisory Board. CAC, Child Advocacy Center, that is where they do forensic interviews of children. CANS, this is important. This is a document that you want to request from the state when you do discovery, the child and adolescent needs and strengths. CAPTA, CAPTA, is Child Abuse Prevention and Treatment. That is a law that was passed in 1974 that created the Title IV funding. And you don't have to know it exactly, but you kind of want to be familiar with what it is. And I think we've talked about that in some of our prior trainings as well. CASA, Court Appointed Special Advocate. We've talked about that today. This next one, a CBCAP. This is kind of the buzzword of the future. This is community-based child abuse prevention. Basically means that we focus on building community-based programs and services. I know on the East Coast and the New York area, this is the one thing they're really trying to focus on. I know that Title IV is once this tries to articulate it, there's a lot of reason it's not happening, but that is the goal of the future, is to have CBCAPs. CFS is Child and Family Services, which is sometimes Child and Family Services can be an outside contractor as well. And CFSR is Child and Family Service Plan. That is another document of CPS that you want to make sure that you have in discovery. All right, here we go. So here's another page. It's going to take us up through H, so you can see we're moving right along. These are the CFSR, the Child and Family Services Review. Now that is so Child and Family Services Review is a requirement of CAPTA, but it does not involve parents and families, unfortunately. That's something that they do. They bring in people from Washington to review some of the files and reports of the state agency. And unfortunately, I think it should involve family feedback, but it does not. The CFTM, the Child and Family Team Meeting, I say there's no team about it. They need to put a new word in there. I call it the Child and Family Totalitarian Meeting. But it is where the plan for the child is supposed to be developed, which means what the parent needs to do to resolve any issues that would prevent return of the child. CIP, Court Improvement Plan, that is a funding program through the Department of Justice that offers grants to states to help provide additional assistance for things in the courtroom itself, such as an extra use service officer, etc. CM is case manager, which is the DCS manager or CPS manager. CPR, case process review. Now, I put this in here. This is not one that you hear very often. I'm not even sure actually who does these. This is not one that we do much of in Tennessee. SIPIT, that's an important one to know. CPIT, which is the Child Protective Investigative Team. The reason that's important is because that's the team that initiates the criminal investigation on a parent, typically. So you will see in the records that there was a SIPIT team meeting, that they reviewed the allegations of abuse as to whether or not they would be criminally prosecuted. CPS, we all know that is Child Protective Services. That's really the generic name for every state agency doing CPS investigations, etc. CPR, Child Process Review. I kind of put this up here in the case process review. So these are different acronyms that are used within different states. This is not one we use much in the state of Tennessee. The DA is the district attorney, or if you're not familiar with this at all, this is the criminal prosecutor. This is the person who's employed by the state who will bring criminal charges. DEI is not diversity, equity, and inclusion. It is drug exposed infant. All right, so you'll see DEI in some of the CPS records and some of the hospital records, etc. DOB, that's I think an easy one, date of birth. ID is intellectual disability. DD is developmental disability. So if you don't know the difference, this is just the cognitive mental, intellectual disability is cognitive mental area. Developmental disability has to do more with just developing socially, not developing proper social skills, and not developing emotional stability, etc. ED is emotionally disturbed. EFC is extended foster care. That is for the children who have aged out of foster care and they allow them to stay in foster care after they have turned the age 15. The foster parent continues to draw down money on them. And often the child gets some other benefits with that as well, as including a per diem. ERP is an emergency response plan. Usually that could be something that is put in a permanency plan. If a parent, especially if a parent has substance abuse issues, they may require the parent to create an ERP, which is, or sometimes call it their contingency or relapse plan. If what will they do with the children? This would mean, for instance, that they would have a relative available that they understand that if they are going to use, that they have to have an alternative placement for the child to keep them safe. FASD, fetal alcohol spectrum disorder, which is if the child has been exposed to alcohol in utero. FAST, this is an important one for records. This is a records document with CPS, the Family Advocacy and Support Tool. We want to make sure we ask for the CANs and the FAST when we ask for records in discovery. FC, foster care, it's an easy one. FCRB, Foster Care Review Board, very, very important. There's supposed to be a foster care review board every 6 months, which the parents and the children are required to attend. And this is a requirement of funding that they have these foster care review boards. Now, unfortunately, the foster care review board is created by individuals who are selected by the juvenile court judge. So sadly, I feel like sometimes we have some bias built in there that we're not getting people who are truly independent. And I'm also finding they're not filling out the forms properly. They're not allowing the parents to speak. They're not having the children present. This is something right here that we can really hammer them on because they're not doing this appropriate at all. FFA is a family functioning assessment. This is another document that is created by the agency, the FFA. So now we have the CANs, the FAST, and the FFA. We want to make sure that when we do discovery, we have all of those listed in our discovery request. FSW is the family service worker. This is when a child is not in foster care and they are trying to provide some services to the family to keep them at home. That would be the FSW. FTT, you might see in some medical records. That is the failure to thrive. GAF is the global assessment functioning. This is a mental health evaluation. They don't use it quite so much anymore, where they would score a person from 1 to 100. And I've been around long enough that I've seen this in many, many times, the GAF score, but it's actually, I mean, it's quite humorous and they're easy to cross-examine on. I don't think they use it too much anymore. HIPAA is the Health Insurance Portability and Accountability Act. This is to ensure privacy of information, of health information. All right, this is page 3. I think we just have 4 pages, so keep your fingers crossed. The IA is internal affairs. So if there is a complaint made on a social worker, when you're looking at the records, you want to make sure that you get the IA reports, the internal affairs reports, or internal investigation reports. ICPC, Interstate Compact for the Placement of Children. So this is what's required if, and this is a treaty between the states, okay? This is not a foreign treaty. This is a treaty. So they call a treaty between the states an interstate compact. And there's other interstate compacts. I don't know exactly what they are because it's not my forte, but for instance, about interstate highways, there are certain interstate compacts that they're going to accept the responsibility of keeping those highways clear and taken care of that travel between the states, etc. So in the interstate compact, if you have a child in Tennessee and you want to send them to Ohio or any other state, you have to go through this whole process. You have to go through this whole process of making sure you do home studies, background checks, etc. ICWA is a federal law, the Indian Child Welfare Act. That is a federal law that has to do with the steps that you have to take if you have a child who is in a recognized tribe. IDEA is the Individualized Education Plan. I can see I did a misspell there as well. Please forgive me for that. But it is the Individualized Education Act, is IDEA, Individualized Disability and Education Act, I believe is what it is. I'm not an education expert. I have an education expert. I leave all that to her. But if a child is in foster care, it is critical that they continue to have their IEP, their individualized plan, follow them wherever they go. IPA is an immediate placement agreement. So the CPS can come in and they can, instead of putting a child in foster care, they can enter into an IPA with the parent in which that parent will agree to take certain safety measures or place that child in alternative placement for a period of time without going to court, and then maybe the situation can be corrected. IRB, Institutional Review Board. This is one that is directed at group homes and institutions. Title 4B and Title 4E are the next two, and those are the sections of the Social Security Act. B provides for preservation, and E provides for foster care. JCCO is a juvenile court commitment order. This is for a mental health evaluation for juveniles who have been accused of delinquency. JDC is Juvenile Detention Center. That one's pretty easy. JJ, Juvenile Justice, pretty easy. JJDPA is a Juvenile Justice Delinquents and Prevention Act. KP, Kinship Placement, that one's pretty easy. LEA is Local Education Agency. So every county here in Tennessee, and I believe probably every county or what do you call them in Louisiana? It's not township, but you know what I mean. Parish. Every parish has their own local education agency. An LI is a lead investigator. LRE is a very important one. This is a legal term, least restrictive environment. I would take you back to something earlier we talked about today about the least restrictive placement for the child if it is necessary for removal. This is a court finding that needs to be made, and this is an important one to participate in. LTPA is long-term placement agreement, which means that perhaps to avoid foster care, you can agree to a long-term alternative placement other than foster care. Last one here, I think. If not, there's only one more. NACC, National Association of Counsel for Children. NAS, Neonatal Abstinence Disorder. That's when a child who is born who's been exposed to intrautero illegal substances or alcohol. NCANS, National Child Abuse and Neglect Data System. There is a report that's created by NCANS every year. I think that is the child maltreatment report. At some point, you're probably going to want to go through one of those reports. It's a little bit boring to go through, but it does give you some important data to find out what kind of data they're collecting. You will find that it's much like it seems like they're collecting data on inventory and not on children, but it's something that we need to know so that we can make these changes. OCS is Office of Child Safety. OIA is Other Involved in Adult. Now that is a acronym that might appear in an investigation or CPS record, which would be the OIA, which might be, I don't know, somebody's ex-girlfriend, aunt, uncle, whatever. That's not a grandparent. OIG is Office of Inspector General. Won't see this too much, but the Office of Inspector General is who is supposed to be doing the audits and the reports to make sure that this agency is functioning. OT, occupational therapy, is a medical term. Probably most of you know that. And the OJJDP is the Office of Juvenile Justice and Delinquency Prevention, and that is a section of the Department of Justice, the federal DOJ. OJT, on the job training, easy one. PATH, Path of Tender Hearts, a little misspell there. That is just one of the programs that parents can choose to follow. PCP's Primary Care Provider, PD Public Defender. PIP, Performance Improvement Plan, is intended for parents, a sort of an assessment that they can take. A PO is a probation officer. A POA is power of attorney. PP, private provider. PREA is important, Prison Rape Elimination Act, and that is if you're dealing with any parents who have children in a detention center and some of the precautions that they need to take to make sure that the child is not exposed to sexual abuse. PT, physical therapy. PTSD, post-traumatic stress disorder. I think we've all heard that by now. QSR is quality service review. RA, regional administrator. RFP is a request for proposal. RCG, regional general counsel. Let me go back for a second. So RFP is what the agency puts out to try to get private contractors involved to do case management, foster placement, therapy, etc. The RRC, Research Review Commission. RPM, Risk Prevention Management. R/O, rule out, important one to know, especially if you have a medical kidnap case, whether or not there are any rule outs of other diseases or disabilities of the child. RSV is respiratory syncytial virus. I guess that's how you pronounce that. Oh, this is the last one. You see, we go all the way down to Y. All right, SBC, this is an important new item. The safe baby courts are coming up, which if it is a baby that is born to a mom who's had substance abuse issues, instead of removing the baby, they tried to rehabilitate her. SDM, structured decision making, is a therapeutic intervention. SED, seriously emotionally disturbed. Now, we talked about ED earlier. SIU is Special Investigative Unit. That is when there has been a complaint against a foster parent. SME is Subject Matter Expert, and SPG is Subsidized Permanent Guardianship. SPMI, Seriously or Persistently Mentally Ill, and that would be a medical diagnosis, and it could be found in a CPS record, though. SSA is Social Security Administration. SSI, Supplemental Security Income. So a parent could receive SSI. I don't think a child would receive SSI. A child can receive some disability or survivorship benefits, however. STM is Support Team Meeting. TAC is Technical Assistance Committee. TANF I call it TANF. It's TANF. That's how we say it. It's hard for me to remember sometimes. Temporary assistance for needy families. This is a poverty level assistance program. And the way Title IV-E is written, you have to qualify for TANF before you can qualify for Title IV-E. So this is the poverty standards of what it takes for a child to receive food stamps. TC is Team Coordinator. That would be a DCS or CPS employee. TDM, Team Decision Making, which is what the agency is supposed to do with the parents, but rarely do they include the parents in that. This next one is also sort of a buzzword for the future, the TFCBT. They started using that probably about 3 or 4 years ago, the trauma-based cognitive behavioral therapy. And I know the first couple times I saw it in the records, I'm like, what the heck is TFCBT? What's the new thing you got going on now? So it's trauma-based cognitive behavioral therapy is what they might try to use to engage with the child. A THP is a trial home placement, and a THV is a trial home visit. So what these mean is that a child is in foster care, and the agency believes they might be eligible to go home, but they want to do it on a trial basis, so they can just yank them out of the home if it doesn't work, and they don't have to file a brand new petition. TPR is termination of parental rights. TL, team leader, that would be a CPS employee. The UCC, another little typo, UCCJEA is Child Custody Jurisdiction and Enforcement Act. That's when there are more than one state involved and you have a custody order in one state and the child is located in another state. And so you have to make sure you comply with this federal rule. VAP is voluntary acknowledgement of paternity, which is what is signed by a putative father at the hospital when a mother gives birth if she is not married. And the VVCO is a violation of a valid court order. YDC is Youth Development Center, which is a juvenile jail, basically. And a YSO, a youth service officer, who is a court officer who works with a judge, primarily as sort of the coordinator between the court and the parent. So that is often the person that the parent can have direct communication with, especially if they're not represented by counsel. But if they are represented by counsel, counsel can involve them, but it won't really need to. But if a parent needs to know, like, where do I file a motion, etc., they can help them out. Whew, all right. Okay, so I know you forgot what the joke is already, but the answer is in a snowbank. And the question was, where does a polar bear keep his money? All right, hang in there. We got a few more to go. Still kind of technical. I hope you have not gone to sleep yet. You've been very kind. Nobody's been snoring and nobody's been writing on my screen, which I've caught people doing a few times. So here we go. All right, now what is abuse? So we're going to look at what is in Tennessee, what is abuse and neglect. Now, over here on the left, you'll see each state agency has a policy or what they call a work aid that is used to define abuse and neglect, or a criminal code, which is what we're going to look at here in just a second. To make sure that to find these for the state, in particular state, or ask for them in every case. So if there's a California case, an Oklahoma case, say, I need to be directed to the code that would identify abuse and neglect so that we can print that off. We have to take advantage of the fact that today, in today's world, we have access to almost everything online. We have access to statutes, to codes, to policies, to procedures, etc. So we need to make sure we're taking advantage of that and getting the actual source documents in our hands. So Tennessee, so this is not a criminal code. This 371102 is not a criminal code. This is the civil code for abuse. So when a person under 18 is suffering or has sustained or may be in immediate danger of suffering from a wound, injury, disability, physical or mental condition caused by brutality, neglect, or other actions of a parent or caregiver. Severe abuse is any of the following: knowing exposure of a child or the knowing failure to protect from abuse or neglect that is likely to cause serious bodily injury or death, and the knowing use of force that is likely to cause serious bodily injury. Now, that sounds pretty serious. I'm going to tell you, when you read severe abuse like that, that sounds very, very serious. However, that's not all. So specific brutality or neglect can be this. So in the opinion of a qualified expert, the parent has caused or will reasonably be expected. No, the neglect has caused, the abuse or neglect has caused or will reasonably be expected to produce severe psychosis, severe neurotic disorder, severe depression, severe developmental delay, or retardation, or severe impairment of the child's ability to function in the child's environment. and the knowing failure to protect. This statute right here opens the door for anything to be severe abuse. This section right here that says severe impairment of the child's ability to function adequately in the child's environment. I have had psychology experts come to court and testify that they could predict that in 10 years, that child would suffer from severe impairment. And this was a child that was not abused, was not beaten, was not sexually abused, was not starved, was not locked in a closet, but there was a disagreement as to whether or not her parents had fed her enough, which she, was not emaciated. And they argued that they had locked her in her room, which there was never really any substantial proof of. But I've actually seen a psychologist come in and talk about this severe impairment, like they can predict it. All right, now also these are abuse, okay? Trafficking, rape, aggravated sexual battery, promoting prostitution, battery by authority figure, incest, aggravated child abuse, sexual exploitation. And then also the knowing failure to protect a child from any of those specific acts, or allowing a child to be present within a structure where the act of creating methamphetamine is occurring, of course, or knowingly or with gross negligence, allowing a child under 18 to ingest any controlled substances. Yeah, I would say that's pretty serious, and that the child is testing positive. Now, the only problem with this is that they lie about drug tests. They say, well, the child had a positive blue line. They never have it lab tested. They never do lab testing fingernail or hair follicles of the children. And then they say that because there was a faint blue line on a urine screen, the child had been exposed to drugs. So they abuse everything they can. They abuse it. Right, physical abuse, knowingly allowing a child to be within a structure where any of the following controlled substances are present and accessible, which is the controlled one substances, cocaine, methamphetamines, or fentanyl. So even just being in a building where they are, which, I got to say is pretty dangerous. I totally agree with that. All right, a significant injury can be a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment. Now, think about this: a cut, abrasion, bruise, or burn. Okay, so how many children in their play can get injured and get a cut, or get a rug burn, or bump into something and get a bruise, or touch something hot and get a burn? Okay. All of those are considered significant injury. And I have represented a mom accidentally. I'm not going to tell the details because it's so, it's not, it was very negligent. Obviously, it was very negligent. I don't think she should have lost her child, but her child was too close to a stove and got a burn. But it was accidental. It was not done on purpose. And it was one of those stoves, these glass top stoves where you can't even tell they're still on or they're still hot. And the child received a pretty serious burn. So, and then it says involving any of the following: a substantial risk of death, protracted unconsciousness, extreme physical pain, which extreme physical pain, of course, if if there's a burn, a bump, or a bruise to a child, it's all painful, right? Protracted obvious disfigurement, protracted loss or substantial impairment of a bodily function. So, of course, some of this sounds extremely serious, and it can be. And children are abused. I've prosecuted child abuse before. I put people in prison for child abuse. But all of this language here, so much of this can be misconstrued and misused against a parent. I know we're on 31. We're almost done. All right, so what is neglect? Now, here's a whole list of what's neglect. And we're going to kind of buzz through these and preparing a parent to face litigation on neglect. You have to have a copy of the statute that applies to your state. How do they define neglect? This is what I was talking about. Make sure you know how they define neglect. And some of them are not very well defined, such as who is without a parent, guardian, or legal custodian. Okay, without a parent. So does that mean that mom left the kids at home? Let's say the kids are, I don't know what, everybody has a different idea on this, but let's say the kids are 11 and 12 and mom leaves them at home while she runs to the grocery store for maybe an hour, hour and a half at the most. Is that mean a child is without a parent for that period of time sufficient enough to say it's neglect? I think not. All right, the second one is whose parent, guardian, or person with whom the child lives by reason of cruelty, mental incapacity, immorality, or depravity is unfit to properly care for the child. Okay, so the CPS takes this word right here, unfit. They kind of work backwards. They develop an idea that somebody's unfit, and then they accuse them of lacking mental capacity, right? This is what they do. They accuse all the parents of being crazy, and so therefore they can fit under this category. Who is under unlawful or improper care, supervision, custody, um, or who is unlawfully kept out of school? Okay, well, again, that could be right. You don't want to dump your kids off at a bar, right? But on the other hand, if there's somebody in the family has a old criminal record, it doesn't mean that they are, um, um, wait a minute, hold on, it may not be this one I'm looking at, but improper care, supervision, and custody. Okay, so let's say that mom leaves her kids with her sister, and her sister had a theft charge 10 years ago. Does that mean that mom has left her under improper supervision? These things have to be ferreted out. And if CPS is going to turn, let's just take that situation. Let's say the kids are left under the supervision with somebody who has an old criminal record. If they're going to do that, but the parent needs to be prepared to fight it, to address it, to have that person testify and say, I've taken care of the kids many times. They love me. They take care of me, right? So don't just freak out. Sometimes parents see this in black and white, and they see the black and white letter and they think, oh, well, then it must be true, right? It must be true if it's in black and white. Well, I don't know if that's improper supervision, but I guess I did. So I guess I must be neglectful, right? But you have to say, is it truly neglect? Because it is totally a subjective application. Parent neglects or refuses to provide necessary medical care. Well, they love to use this in medical kidnap cases. I've had children with chronic diseases that the parents did not want to get the prescribed treatment, and they've said that's neglect, or because of lack of proper supervision is found in a place the existence of which is in violation of law. So this would be, understandably, this has to do primarily with things like bars. Okay, so in Tennessee, a kid can't be in a bar under 18, right? So they might say that that is improper supervision if they took the child with them to a bar. Who's in a condition of want or suffering, or is under improper guardianship as to injure the morals or health of the child. See, I told you, these are so broad sweeping. These are so broad sweeping that the agencies can take these and twist these. And that's why you have to have an actual black and white copy of it that you put in a notebook or you keep or you put in the parent's file so you can address them head on and you're not being totally reactionary, which is something that most people do. Most attorneys are totally reactionary in these types of cases. Here's a couple more. The care and control of an agency not related by blood or marriage for 6 months or longer. So that is when a child has been in custody for 6 months or who's been left with a relative, even under a power of attorney, which is an agreement, or no longer, wait a minute, or longer in the absence of a power of attorney. Okay, so in the absence of a power of attorney, which is an agreement for that. And then the second one, who's been allowed or encouraged or permitted to engage in prostitution, of course, pornographic photography, etc. So the first one is about just being left, being abandoned and left with somebody. And the second one, of course, we don't want children engaging in prostitution or obscene and pornographic photography. I'll tell you, or posing, filming or posing, a similar activity. This can be read a little broad too sometimes, this whole paragraph here. So again, you need to know what they are and you need to preemptively be willing to address it. Or who's been left in the sole financial and physical care of a caregiver no less than 18 consecutive months. And really this is about developing a relationship. This has a lot to do with grandparents who's developed these strong relationships. All right, so severe abuse, we've already talked about this one, and it also includes mental injury. So let's take a look at mental injury down here. A mental injury means an injury to the intellectual or psychological capacity of a child as evidenced by discernible and substantial impairment in the child's ability to function within the normal age range of performance and behavior with due regard of the child's culture. I'm going to tell you, I don't know who wrote that definition, but that could be so abused and misused and misinterpreted and means an injury to the intellectual or psychological capacity of a child, evidenced by discernible and substantial impairment on the child's ability to function within their normal range. Again, you've heard horror stories about, a girl raised with wolves or inability to communicate, but this could be used improperly against the parents as well. All right, again, thank you, thank you, thank you. And we are looking forward to continue to work with you to slay the dragon of CPS. And if you're not joining us on Facebook with the Family Forward Project, I encourage you to do that. On TikTok, I am putting up some videos there, and you should be watching and sharing those videos. It's no longer under my name because my personal one got shut down by TikTok. So it is now under Family Forward. And then on YouTube, I have the Connie Regularly and the Family Forward channel. The Family Forward channel is for trainings. So you want to find our trainings there. That would be a great place to look for it. Let me get these out of my way. And all trainings are uploaded to the Family Forward YouTube channel. Okay, so we went through our 2 jokes. I don't know, we'll get off the recording here. I'll see if anybody tried to make a guess, but at least you didn't go to sleep. Nobody snored, nobody wrote on my screen. You're here for me to keep me awake while I do some of these trainings because they do seem to get a little weary at times, but they are very, very critical. They are all a must. These are things you have to understand. I have people call me all the time, want to know this, want to know that, and I can't start from scratch with everybody. So a lot of times I will refer people to the training and I say, okay, go watch these, understand what we're doing, understand the process, make some notes for yourself, and then we'll be able to have a more educated education on this issue. All right, so I'm going to stop the recording and we can chit chat a few minutes.